Fast forwarding come our channel so how a GH politics avenue. Podcast stories a trending book is making headlines. Ne jembre ni de bi Akroma ni de mi ahobrak simo me shock say yemon ra yin simo. Na Sophia.A Akufo and amano ka say yebo ewura na so ye. Na K.Pratt etimi atutu bi edi amana no a enya asem goto akra a wa kire say bibie ni wa Secrecy mami yibitimi edi ejaw ewo council of can I say elders aswe ye ho because mama na no tro because committee a ye set ye na nsema ebi piem ewo committee ni mu no ense se epia bonten no mama na dia ba bonten ni de next ensem fata say Mahama no obetime hold anything kind of secrecy be ewo committee ni nti ebeya enka yenyini free committee ni so kra emwa some kro bebre na kan Mr. say emun rain simu.
Right, Mr. Pratt.
Well, first and foremost, I think it's important to recognize that this is the third time that Article 146 of the Constitution has been applied. It was applied in the case of the former head of the Commission on Human Rights and Administrative Justice. And then it was also applied in the case of Madame Sophia.A, then Electoral Commissioner. So this is the third time. Now there's some significant things. One, in the first two instances when it was applied, it was done as the Constitution itself prescribes. The sittings were in camera, the petitions were not published, proceedings of the committee, the special committee, did not find its way onto social media and on the front pages of the newspapers. And this is very significant. It is only in the Madam Tokonu case that the petitions that were sent to the president have found space on social media and in the regular media. Something must explain that development, okay? It is also only in the Madam Tokonu, Justice Tokonu case, that the petition itself and the proceedings of the special committee have been subject to public discussion. Something must explain that. Now for me, the other thing which I find most interesting is that the very actors who interpreted and used Article 146 in the first two cases are the very actors who are coming to us and saying that there is something wrong with the constitutional provision. So let us assume that they are right. How come that when they were the interpreters of the constitutional provision, they were the people acting to give meaning to the constitutional provision, they did not find that it was wrong or that there was something wrong with it? They wholeheartedly, judiciously interpreted Article 146 and implemented it without comment. How many years later, 10, 16 years later, they've come to us and said, oh, the very provision of the Constitution which we used in order to remove the head of Shraj and Madam Sophia.A must be defective. This raises many concerns, okay? Now, Justice Sophia.A Akufo has spoken at least on 2 occasions publicly. Her first complaint was that, look, when she was going to give evidence before the committee, she thought she was going to give evidence in camera. And she did not expect that her evidence would be published. And she's asking the question, who leaked my evidence before the committee? That's very instructive. She's worried that her evidence has been leaked to the media. But who could have leaked that evidence? Obviously, that evidence was favorable to the case of the removed Chief Justice. That evidence was not furthering the case of the petitioner. So ask yourself, between the petitioner and the former Chief Justice, who could have leaked that evidence? Who had an interest in revealing that evidence? It's clear, you understand? It's so very clear who could have leaked that evidence. But you see, it doesn't end there. Madam Sophia.A. Akufo, and I agree, is a respectable member of the Ghanaian society. I mean, I haven't known her much at personal range. Everything I knew about her was through a mutual friend, Rikiyose, the designer. I'm told that she was very close to Rikiyose, and Rikiyose happened to be a very close friend of mine. So I got some information, some knowledge about her and so on from my very good friend Rikiyose, who happens to be the father of Reggie Rock's own. You understand? So that's how I got to know her. My first close encounter with her was when I was invited to deliver the Professor Mills Memorial Lectures, and she came. Okay, so we arrived early, and myself, her, the former president, and two others, were put in a room. So we engaged in a conversation for about 30 minutes or thereabout. And in that short conversation, it struck me that she was a woman of integrity. Okay. Her own activism after she had left the Supreme Court was a demonstration that this was a woman we should salute. Even if you disagree with her, I mean, her courage in stepping out into the public domain to engage in activism as a former Chief Justice was highly commendable. So this is how I've known her, you understand? But there are problems. Proceedings at the Council of State, to all intents and purposes, are confidential. So this woman, this lady, this highly respected lady, sits in the Council of State and, for all we know, took part in decisions on this matter. She then leaves the Council of State and goes to the Committee of Inquiry to give evidence for the one whose conduct is being examined. It's messy. Very messy. Exceedingly messy. And how do you explain that? That a member of the Council of State, after the Council of State has contributed in referring a matter to a committee to investigate the conduct of the Chief Justice, leaves the Council of State, goes to this committee to give evidence. How then is she able to go back to the Council of State and work with her colleagues? It's so messy, it's unbelievable. Yeah? Then, after the decision has been taken, she comes back to the public and says that a certain threshold was not reached. Whose threshold? What legal instrument, what law established that threshold? We are not told. So it gets messy and messy and messy all the time. You understand? Now, one of the most important questions which has been raised is that when she was handling the Charlotte Osei case, did she then know that the constitutional provision, as in Article 146, was defective? And if she knew, why did she, on the basis of the provisions of Article 146, proceed to make decisions on Charlotte Osei? Okay? Now, beyond this, it's also something in the Constitution, especially Article 146, which we are not looking at. You see, this committee included two members of the Supreme Court, 2 Supreme Court judges. And to all intents and purposes, one would even can argue that in terms of number of years served and so on, Justice Poma is senior to her. Okay, is senior to her. So to some extent, there's a measure of peer review. And in fact, it is important to make the point that throughout this process, the president at no time made any decision on his own. A petition was sent to him. He referred it to the Council of State for advice, which advice the Constitution does not allow him to disobey. So that decision was not his decision. That, to a very large extent, was an instruction from the Council of State which he had to follow. Now, if you read Article 146, I think 9, it's also clear that when the committee he has established makes a decision, he cannot vary the decision of the committee. So it was not President Mahama who decided that the Chief Justice should be removed. It is the committee who decided that the Chief Justice should be removed. President Mahama's role as president is only to implement the decision of the committee. So why blame him? Now, for me, the other significant thing is that on 7th January this year, the Chief Justice who has been removed is the person who administered the oath of office of President Mahama. What did that oath say? That oath said that he would defend, uphold and defend the Constitution of Ghana. Not parts of the Constitution of Ghana, including Article 146. The oath he took, the oath of office he took, did not empower him to come to conclusions as to which part of the Constitution is correct and which part of the Constitution is not correct and so on. He took an oath to defend the whole of the Constitution. And that oath was administered by Justice Tokon. Do you understand what I'm saying? Yeah. The oath of office he took was administered by Justice Tokon. So it is strange that today, more or less, I mean, and Justice Tokonu did not come as an individual, she came as an institution. She administered the oath as head of the judiciary. Okay. So the very institutions which administered this oath are saying that no, we were mistaken in administering the oath. And that in spite of the fact that you have taken an oath to defend the Constitution, there are some parts of the Constitution that we disagree with which must not be obeyed. What is this? I mean, I can't understand this. You know, it's so difficult to understand this. But then, hey, they are the judges. They are the people who went to law school. I didn't go to law school. For me, as an ordinary Ghanaian citizen who has never been Chief Justice before, who doesn't even know the law, who is considered to be a lay person and so on, I expect my president, whoever he is, to follow the law. That is what they call the rule of law. When you hear people talking about the rule of law, it just means that follow the law. Even if the law does not make sense. If the law does not make sense, there are processes for amendment. When the amendments have been effected, we have a new law, and then you have to follow it. But the law has not been amended. The law is the law. You understand? The law is the law. So what is happening? What's all this rigmarole and so on? Now, there's a substantial question which needs to be answered. You understand? And should be answered by all of us. Now that the respected former Chief Justice has acted in this way, can she be trusted with confidential material? I don't know. I'm just posing a question. The Council of State is where a lot of confidential material will go. Who can trust her with confidential material? Her colleagues, members of the Council of State, how are they supposed to act with regards to her? Is she going to go public with their decisions and so on? Is she going to criticize decisions that have been made and so on? Raises a whole lot of questions. Now, you see, for those who think that this matter was treated lightly, as something which can be, they should look at the facts that have been made available to us. One, this committee considered 10,000 pages of evidence. Can you imagine what that is? 10,000 pages of evidence was considered by this committee. The Chief Justice was represented by 4 lawyers, including a former Attorney General. The petitioner was also represented by 4 lawyers. This is the weight of the matter we are discussing. The Chief Justice called 12 witnesses, including experts. The petitioner called 13 witnesses, including experts. So this is the weight of the matter we are considering. 10,000 pages of evidence. I wish I could have that. And don't forget, the committee itself was composed by 2 Supreme Court judges, plus a former Auditor General, plus a soldier, a senior soldier, high-ranking soldier, and somebody else. And a lecturer from the University of Ghana. Is this a matter to be taken lightly? And so on. So look, I think we should move forward. If there are persons in our society who legitimately and rightly have concerns about Article 146, there's a constitutional review process currently ongoing. They should make their inputs. Let's do it properly. If we think that Chief Justices should be above certain provisions of our law, let's accept it. You understand? As far as I'm concerned, the law only makes sense if the principle of the equality of citizens is applied. The law makes no sense any longer if the principle of equality of citizens is sidestepped. Okay? So those who think that there's something wrong with Article 146 should tell us. Now, they are saying that there's executive interference in the affairs of the judiciary. Read the Constitution very closely. If you read the Constitution very closely, one of the principles which is upheld by the 1992 Constitution is the principle of separation of powers. Inherent in that principle is the notion that no authority is supreme. No authority is above the law. So the 3 arms of government act as checks on each other. So the judiciary is not that independent if you apply the principle of the separation of powers and so on. And the legislature is also not that independent. And that is why when Right Honorable Abem Bagwin made a decision about the members of parliament who were deemed to have vacated their position and so on, the matter went to the Supreme Court for a determination. You understand? Because otherwise, the legislature should have taken its own decision and should not have been subject to review by any other organ. So the principle of separation of powers gives the executive a role to play in the determination of some cases regarding the legislature and the judiciary. And the legislature also has some role to play in the determination of some cases regarding the executive and the judiciary. And the judiciary has roles to play in the determination of cases regarding the legislature and the executive. This is the principle of separation of powers. Finish.
Right. Thank you very much, Comrade Pratt. Several messages have come through. I'll try to read some more. Our time is almost up, by the way. If we can briefly touch on the last topic, the MPP. The Archives newspaper said 3 defeats in a row leave MPP in shambles. Appetite for re-election vamooses, but arrogant posturing continues. I'm sure this is in the wake of what happened in the Akufo by-election. They were so very confident that they were going to win.
I beg you, I will make a very short remark.
Right.
There are so many.
We ayan sama ro timi ko so channel no so mam no asesa wodi mre wa da sanin so ba de ndom bi edom ya ne am. Oni ayan sam mu mre man ne so mo kwan so kosokra. Aha, politics avenue.